tribunal matter. It is a matter between the SIU, Special Investigation Unit, versus LEDA, Structural Development, plus 43 others. It's under case number GP 07 of 2020.
Please, Your Lordship, my learned friend Mr. Tabani Mbisa and I appear for the applicant, the SIU.
My Lord, I appear for the first respondent, the 13th and the 14th. I'm led by Mr. Mothle.
The first?
The first, 13th and 14th.
Third or first? I'm not sure.
First one.
First one.
Yeah.
I didn't see the first respondent's affidavit.
It has been served, I think it has been served by email. I think a number of my colleagues have received it. And I have a copy here, my Lord, if I can hand it out.
When was it served?
It was served last week on Monday and Tuesday. Monday, another copy was transmitted, and then the other copy was then sent again on Tuesday. And then it has a combination application as well. The 2nd of October. So,
Pardon?
2nd October.
It looks like I'm in possession of affidavits that were filed before the 25th of September. And I'm aware that there are others which came after the date. And, well, we'll talk about that later. Let the others introduce themselves. Yes.
As Your Lordship pleases, I am the Toy. I appear for the 2nd, the 15th, the 20th, and the 22nd respondents, my Lord.
That's Mr. Dito. Yes.
Yes, my Lord.
Yes.
Numbers. Do I need to repeat?
Pardon?
Do I need to repeat my...
No.
Thank you.
I've heard you. Thank you.
And may it please the court, my Lord. I'm Mothle. I'm appearing on behalf of the 3rd respondent, together with the 34th respondent.
Yes. Thank you.
Nice to meet you. Yes, thank you, my Lord. I appear on behalf of the 4th respondent, Advocate Witts, and I also appear on behalf of the 38th respondent, that is the director of the company's personal capacity. We did file our papers. We also filed a practice note as well as short heads of argument, and we haven't been able to deliver hard copy because of the logistics. We're not sure whether it must go to, so we've got them available here. If there's somebody from the state attorney on behalf of the applicants, we're happy to give them the originals. We did do it electronically. It's all been done and it's all been served. But yes, the actual physical copy, we don't know where to file it. Either at Boyson's or
here.
The
offices of the special tribunal at the Boyson's Magistrates Court.
Then we'll file the originals there.
Must be filed, yes.
Thank you, but it has been done electronically. Everything's been done, etc. Thank you, Lord.
Okay. We are not yet, just for the record, we are not yet on case lines.
Correct.
So documents, if they are emailed, the hard copies must follow. You may serve, but filing is with the registrar's office at Boyson's.
Thank you, Lord. I think we'll all take note of that. There are a few of the respondents in the same position.
Yes. Okay.
So it's all been done electronically, but we'll make sure that ours are filed at Boyson's.
Yeah, okay.
Thank you, Lord.
Thank you.
As the court is, my Lord, my name is Gandhi Patela. I appear for the 30th respondent.
30th?
Yes, my Lord.
Yes.
Please, my Lord. I appear together with Mr. LaRue for the 31st respondent, that's Boxing.
31st respondent. Yes.
Thank you, my Lord.
My son is Mothle. I appear for the 8th respondent.
8th respondent.
As the court pleases, my Lord, my surname is Fontonda. I'm acting on behalf of the 9th respondent.
Thank you, Mr. Fontonda.
Please the court, my Lord. Surname is Van Zyl. I'm appearing for the 28th Sasol.
Van Zyl?
That's correct.
Yes. Thank you, sir.
Please the court.
Please, the court, my lord. My surname is Many. My name is Sazi. I appear for the 5th respondent.
Fine. Yes, thank you.
May it please the court, my lord. I'm Kotsopwane, appearing on behalf of the 42nd respondent, led by Thandisizwe Diko.
42nd?
Yes.
42nd respondent. You led by? Oh, Mr. Nkukaitobi. Yes, anybody else?
As the court is my lord, I appear on behalf of the 35th respondent, Jamal Trading.
35?
Indeed, sir.
Yes. You are?
N. Moving Sending, initials N.
Yes. Are we all on record? Okay, Mr. Kennedy, I received a letter last night, and I don't know whether it has been served on everybody else.
Lord, I hope that it has been served on everybody else. We've also been in oral contact, or in some cases email contact, with those opponents that we were able to contact as well directly with counsel. And we've also had some discussions with counsel this morning and the attorneys this morning who were available. My Lord, the position effectively is this. Your Lordship refers to the letter. It was sent simply for your Lordship to be informed of the development. My Lord, on the previous occasion, in the order that your Lordship granted on the 20th of August 2020, your Lordship made provision for the filing of notices of opposition and answering affidavits. What then happened subsequently, my Lord, was that some of the parties anticipated or sought to anticipate the return day and came before your Lordship in a case management meeting chaired by your Lordship, which I was unfortunately not able to attend, but my Lord Junior did. And then...
It was chaired by Judge Makanya.
I beg your pardon, it was in fact your Lordship's brother. That's quite correct. Thank you. Thank you. That was on the 9th of September. And your Lordship's learned brother issued a directive as to the filing of answering affidavits. 25th of August. 25th of August. I beg your pardon, for us to file a replying affidavit. Now, my Lord, what has complicated the matter and what renders it, we submit with respect, not right for hearing, and it seems that at least all of those colleagues that we've had contact with in our communications yesterday and today are not resisting that notion, although some of them don't feel particularly happy, and we can understand why. The reason is, my Lord, that we have had in the last week a flood of further answering affidavits way beyond the time that your Lordship specified in the previous, or your Lordship's brother, Makanya J, specified in the case management directive. And my Lord, there are at least 5 answering affidavits that we've had in the last week. And some of those, my Lord, are quite lengthy. In fact, in total, they combine into, by my rough estimate, I think roughly 300 pages. But there are 5 separate affidavits. There's one further one that we weren't alerted to as counsel that apparently slipped between the cracks. So that would make it 6. And our learned friends leader for the team for the first respondent has indicated to me informally, my Lord, that the other respondents that he and his learned junior represent, the 13th and 14th respondents, are still intending to file a separate affidavit. They are directors of the first respondent letter. My Lord, we're not wanting to make an issue now about the lateness of the filing of their affidavits. Obviously, it inconveniences the most important person being your Lordship, as well as other parties, including ourselves. But the upshot of it is, my Lord, that the matter requires replying affidavits to be prepared in response to those answering affidavits that have been filed late. And we would submit with respect be appropriate for your lordship by way of case management today if you accept the terms of the draft order that we're going to hand up. We've suggested timetable. Perhaps, my lord, I can just hand up.
Can you just this thing is making enough. Somebody else is
May I, with your lordship's leave, hand up a copy of the draft order that we have prepared. I've changed the court heading for those colleagues who've received a copy as well, and I hope everybody has or has one accessible. We weren't quite expecting the huge crowd of opponents today. I bought 3 copies, but it seems that may not be quite enough. With your lordship's leave, may we then hand up that copy? And my lord, it provides, subject to your lordship and your lordship's diary being able to accommodate the matter, it provides for the matter to be postponed for argument to the 8th of December for argument. My lord, my learned friend Mr. Ditoy has suggested that it may be prudent, and we would agree with respect, and that he is counsel for the second and certain other respondents. It may be prudent for your lordship if you can accommodate us on the 8th to make provision for additional days immediately thereafter, because of so many respondents possibly arguing the matter in due course.
Let me tell you, yes, before I give my view, I'm not the date to which you want this matter postponed is too far out. Respondents had the whole of September to file their answering affidavit. The deadline for that was the 25th of September. And those who filed after the 25th of September were way beyond the order that was given. But then to postpone this thing to the 8th of December is taking this matter really right up to the end of the year. I have a different date, and my date is that I want you to hear you, each and every one of you on this one, or if you don't mind, I can adjourn so that you talk it among yourselves. I'm of the view that this matter can be heard on the 15th and 16th of November. 15th and 16th, because the period you gave for the filing of heads for me is rather too long, especially the respondents, because most of the respondents have already filed their answering affidavit and they've had sight of your replying affidavit, and they're in a position to start with their heads right away. I cannot see why we cannot have as deadline for the heads of argument for the respondents to be filed by the 8th of November, and then the following week, the 15th and 16th of November, 2 days, we hear this matter, so that by the end of November, I'm certain that the judgment will be delivered. And let's wrap this thing up by the 8th, by the end of November. Not allow it to go into December. If you want to discuss it among yourselves, I can adjourn the court for a few minutes.
Thank you.
But that is my view. The rest, I won't comment on what is here, except to say that the order was granted in mid-August. When I granted the order, it was sometime in mid-August. And it said within 5 days, those who intend to oppose must do so. 5 days of service, of receipt of service. And After that, after receipt of the notice to oppose, then they had a further 15 days to file their answering affidavits. That was in September. That's why I find it very difficult to understand why there are people who are still drafting answering affidavits now. Unless they show me that they were recently served with the order. But if they were served with the order in August, then I cannot see why this matter should go to December. I have a very great difficulty with that.
May I just check your Lordship's indication is the 15th and 16th of November?
15th and 16th. I've already considered that because of the number of parties, one day won't be sufficient. Yeah. We may have to put aside 2 days. Probably 3.
The 15th, my Lord, may I point out, is a Sunday, so perhaps your Lordship has 2 dates.
Let me see what I have here.
16th is a Monday.
Yes, 16th. It should be the Tuesday of that week. Let me see. Tuesday and Wednesday of that week of November.
That would be the 17th and 18th.
Yes, the 17th and 18th of November.
Yes, my Lord, perhaps we should take up your Lordship's kind suggestion of standing down.
Yeah.
I have a difficulty. I'm not available those 2 dates.
Oh.
If I have to drop out, I will, but obviously...
No, I wouldn't suggest anybody dropping out, but...
Thank you, my Lord.
Let's all, because it's going to be difficult to accommodate everybody.
Yes.
Some other council may be having matters elsewhere,
yes,
but we must arrive at a date where we finish this matter.
Yes, my Lord.
Because I spent the whole weekend preparing for today. I thought we will proceed today. And now I hear it has to be postponed. In all probability, I'll be the judge presiding on this because we don't encourage that judges should take a lot of time reading papers and then the next thing, some other judge will have to start again reading the papers, you know. So we have to finish this before the end of November.
As your Lordship pleases. May we then ask for the stand down now, my Lord, and then perhaps hopefully reach some sort of consensus?
Yes, but before I do, let me check if there's any council who has not received that letter that is being spoken about and who's not aware of what we are talking about. Mr. Kennedy, I think you need to bring some of the council. I see there are 2, 3 hands up. It looks like they don't know what we are talking about.
Yes.
So you'll have to bring them up to speed.
We'll do so perhaps in the stand down.
Yes, I expect all senior council to assist me with this. We have to bring it up to speed, and let's arrive at a date so that we're able to finish this thing, because there are other matters waiting, and already the date, that week of the 8th, I'm not available. And I've been assigned to do this matter, you see. That's why I say let it come in November.
As you wish.
Okay, we'll adjourn for a few minutes.
Thank you.
Yes, Mr. Kennedy.
Lord, may we firstly thank your Lordship for the opportunity to confer as teams. My Lord, there is consensus, but it may not address sufficiently your Lordship's concern. There are major availability problems with many of the council right through November. We were looking at one stage at a Friday here and another Friday there, but that hasn't suited everybody. My Lord, the closest we can come, and this we seem to have complete consensus on with availability and agreement to this, is the 3rd and 4th of December. Now, we appreciate it doesn't satisfy your Lordship's concern that it should be before the end of November. It's fairly close though. It would be the week, the Thursday and the Friday of the week before that we propose. So I'm afraid we haven't been able to completely address your Lordship's concern. But that is the consensus that has been reached by all those who engaged in the discussion now, and suits the availability. In one case, I can't remember, I think his name is, I'm afraid I can't remember, one of our colleagues is not available right through November in any event because he'll be acting. But he says that he has to drop out of the matter.
I can understand the time frames you have stated for filing of affidavits.
Yes.
For me, those are important documents that are needed.
Yes.
Yes, that's evidence. But the heads, because one council stood up to say they've already filed even their heads.
Yes.
Heads can be drafted now for those who have already filed their affidavits and have received your replying affidavit to their case. And I cannot see why we should spend another 3-4 weeks on the heads.
Lord,
let's try and save there, because as I say, the last 2 weeks of December are the weeks on which are reserved for judges to do parted matters and so on, because that's towards the end of term. And while I'm working on the special tribunal matters, I'm also working on the High Court matters. So my diary is equally full. That's why I'm trying to accommodate everybody here.
Yes, Lord.
Yes. We cannot spend so much time because people did not comply with the court order.
Indeed, Lord. My Lord, may I suggest we, in fact, only dealt with the dates which were problematic for the hearing.
Yes.
But, my Lord, may I suggest, subject to our learned friends' input, that our heads of argument can be filed earlier. Our replying affidavits have to be filed by the 26th. Can I suggest, my Lord, that we would file our heads by the 28th of October?
Yes.
And the respondents shall all file their heads by the 4th of November.
Yes, if they start with their heads now, they wait for your heads. As soon as their heads are filed on the 28th of October, they just have to make whatever adjustments they make and file.
Indeed, my Lord.
Then we can wrap this thing up in November, really. We shouldn't really play around with the time. There are only 8 judges in the special tribunal appointed by the president.
Yeah.
And all of us are having one or other matters to be addressed during that period.
Yes.
As you are aware, I have a matter in which you are appearing on the 3rd of November.
Correct.
So I really need to wrap this thing up before the end of November.
Lord,
I don't know if anyone has a difficulty now. If you will be able to file by the 28th of October, the heads, which many of whom can start doing so now, those who are ready, and the 4th November. If people are not available on that week of the 17th, 18th, how about the 10th and 11th of November?
my Lord, my personal difficulty is that I'm leading a team leading evidence at the Zondo Commission that week and prior to that relating to Denel. And I'm afraid the Deputy Chief Justice has, as your Lordship will understand, extremely limited time available because his commission has to come to an end by the end of March. And he's going to have to spend a few months. So I'm afraid in my discussions with the DCJ, there is no flexibility in relation to that week.
How many days in that week? You say the 17th?
My Lord,
Is
that's...
it the 10th, 11th, and when?
Yes, it's the entire week from the 9th to the 13th that has been set down for Denel witnesses. There's another week at the end of October for the same issue. My Lord...
Okay, October is stretching it a bit
My
too
Lord,
much. I don't expect us to argue in October.
Yeah.
Let's look at November. And
My Lord, I have some dates, very few, but I have some dates available in November, but they're not continuous. I'm available the 20th and the 27th, which are both Fridays, when the arbitration I'm chairing will not be proceeding. But, my Lord, I am aware that some of our colleagues indicated, I think Mr. Mukatobi, for example, who's acting for the Chief Financial Officer, who still has to file an answering affidavit. I understand he's not available. That's for the 42nd respondent, Ms. Lehloenya. And Johan, I think you're not available.
No, I'm available for those 2 days.
20th and 27th. My Lord, some of us are available on those 2 days, the 20th and the 27th.
20th and 27th.
27th, yes.
Mr. South, what was the position?
Our junior and are available on those dates.
On that date. Okay. Is there anybody else who has a problem with that? Yes, sir.
The only problem I have is with the 27th, Your Lordship.
The 27th?
The 27th. The 20th, I'm fine.
My Lord, in relation to this particular colleague, I'm afraid. Badela, I'm sorry, Mr. Badela, beg your pardon, beg his pardon. He did raise that difficulty earlier. And what I suggested to him, my Lord, but I can't prescribe to any colleague, obviously, particularly when they're on the other side. But what I've suggested to him is that we should try and reach agreement as to when council should argue and for how long. So we will
yes.
I'm sure that
will
will help
to
you.
be regulated.
Yes. And particularly once the heads of argument have been filed, we'll be able to see what issues are going to be ventilated. What I've suggested to my learned friend is that we should accommodate his argument on the first day, which would be the 20th. And then if he's not available on the 27th, then if he wishes to be here, if he becomes available, that would be fine. But at least he will be given the chance to argue on the 20th. Is that okay with you? I'm sure
that week.
I'm sorry?
People having problems earlier that week. I'm looking at
I do know.
23, 24, 25, 26.
I'm afraid that is one of the weeks when I'm chairing an arbitration.
Oh.
But not on the Friday. For some reason the parties have elected not to sit on the Friday. So that's why only the 20th and the 27th are dates available to me.
This is becoming a nightmare. It's really becoming a nightmare. Who else is having a problem 20th, 27th?
If I may, not in the line of a problem, but if I may perhaps suggest a practical arrangement in terms of arranging which parties argue on which dates. If your Lordship could perhaps direct that in the week of the 9th of November, that the parties should all convene a Teams meeting jointly, at which meeting we should agree on what dates which parties are to argue, and that should leave enough time to then also provide your Lordship with that information, if it's convenient to you.
You want to settle the dates on the 9th? The dates of hearing?
We could, if that's a practical measure. It seems that we're trying to herd cats, not the dates for the hearing, but the dates when on the 20th or the 27th.
Or the time.
Parties are to arrange, and it may assist with respect, my Lord, just the herding of all these cats. If we could have an indication, perhaps, and we can set the time as per your Lordship's guidance, perhaps at 5 o'clock sometime during that week, and arrange it all by teams. so that we can, as all the parties, then give your lordship an indication as to which parties are to argue on which dates and the appropriate times. And please the court.
Let me throw a curveball to all of you. Is there anyone having objection to work on Saturday the 21st? I'm prepared to.
No.
We sit on the 20th and the 21st and we wrap this thing up. Then people are released for the 27th to do whatever. Is there anyone who has a problem with that?
No, yet.
Let's consider that. 20th and the 21st, and let's wrap this thing up. And as to the venue, it may not be this court. We'll have to come back to you on that one. You will hear from me about the venue because it has to be arranged. We arranged only today for this matter to be heard today. But now that it is not being heard today, I still have to go back to the drawing board. I still have to talk to Judge President Mlambo about an available court that will accommodate all of us, bearing in mind the regulations about COVID and all that. So we will let you know in time the venue where all that will be heard. But I would strongly go with the 20th and the 21st Saturday. Let's finish this thing once and for all and then get it behind us. I'm aware that most of you have other matters to attend to. We are used to working Saturday, Sunday in the urgent court, so it's not an issue. I'm prepared to do that if it suits everybody. Will that be fine? Mr. Kennedy, I'd like to hear you. If there's anyone who has a problem, please raise it now.
As I understand it, nobody is raising an objection. My Lord, I'm sure I speak for everybody when I say that the parties are grateful that your Lordship is prepared to sit on a Saturday.
Yes.
There are some parties that need more time or have asked for more time or are taking more time. There are other parties that want the thing expedited, and certainly our client, the SIU, is one of them. So we are grateful that your Lordship is able to accommodate it on those dates.
Yes.
My Lord, there...
Just a minute before you proceed, I see Mr. Mtlong was standing up.
Indeed, my Lord.
You want to play golf on Saturday?
No, I don't, my Lord. My Lord, I'm sure I will be available on the Saturday. I'm just battling with my diary because I can't switch on my phone now. That's gone completely flat. I have an advanced party matter in Pretoria. It's a civil trial. And I'm sure if it overlaps, it could only be on that Friday. But the Saturday, I'll definitely be available.
Okay.
Yes.
Apartheid is set down for when?
That's what I'm battling with. I know it's in November, but I can't confirm the date now.
We'll all keep you in our prayers. That you'll be available on the 20th, and let's wrap this thing up. Yes, just check and inform my clerk if there are problems.
Indeed, my Lord.
Yeah, so that we see what we can do. We may accommodate you. It will be, I wouldn't like you to come in only on the 21st because we shall have missed out what your other, what the SIU has said on the 20th. And so I hope you'll be available for both days.
As a copy.
Okay, then can you rewrite this, Mr. Kennedy, the revised date on the proposed draft order?
Yes, Lord.
And let's put it that way, and then the rest I have no problem with, but I'd like us to finish this thing.
Thank you.
Just redraft the revised. We can change them by hand there, and I will read out the order. And please, those who still have to file affidavits, we are really bending backwards to accommodate people here. People had the whole of September to do it, and we are now in October and people haven't filed their answering affidavits, and that's what I find very troubling. Deadline 12th October, that is next week Monday. Beyond that, I'm not taking any other answering affidavit.
Thank you, Lord.
That one stays, yes.
I'm sorry.
Yeah.
My Lord, we'll attend to the changes to the draft order. May I just confirm so that before we do that, there's no controversy later, our understanding of it. Paragraph 1, we'll read now the matter is postponed to 20th and the 21st of November for argument.
Yes.
I won't read out the irrelevant words, my Lord. Paragraph 2 stays the same, so does paragraph 3.
Yes.
That's for answering and replying affidavits. Paragraph 4, the change will now provide for the filing by the SIU of its heads by the 28th of October. And paragraph 5, that all of the respondents will file their heads by the 4th of November.
Yes.
My Lord, before we attend to correction of the order, I'm afraid we have a difficulty in that, again, my pile of copies has been distributed. I don't have a clean copy. Perhaps I don't. Thank you very much. Thank you. We'll supply a learned friend with a proper copy later to replace it. My Lord, may I just deal with a couple of side issues that should not need to give rise to any controversy or argument. But
The
maybe.
first one, Mr. Kennedy, Council there made a suggestion that there should be a meeting of all of you where you divide up the time.
Indeed.
The last date for filing of heads for the respondents is the 4th of November. So thereafter,
Yes.
we'll be having a picture, all of us, and I hope I'll also be having the full set, all of us, as to, where we are going in terms of the issues.
Indeed.
Then you can divide up the time in terms of who goes first. Obviously will be the SIU, and then and who will follow, and so on.
Yes.
Ordinarily we would follow the number as it stands of the respondents, but there are other council who represent different respondents spread in the
Indeed.
among the parties. So you will work it out.
We will.
Yeah, and I'd like to know before the sitting.
Certainly.
If you have reached an agreement. If you haven't, I will have to work it out myself.
Yes, ma'am.
Because I want to be fair to everybody. That's the whole thing.
Certainly.
Yeah.
My Lord, may I express our gratitude to our learned friend, Mr. Witzel, for making the suggestion. It's a good one. And we have a good spirit between all of us colleagues, some of whom we know for many years, some I've just met this morning. But there seems to be a good spirit among us. And there should be no difficulty.
Yes, if you do it by video conferencing,
yes.
You don't have to meet at a particular venue. I mean,
Indeed.
you just agree on the time, you get on the video conferencing.
Indeed.
And come to some understanding as to, how much time
Indeed.
you can divide among yourself in terms of each one.
My Lord, what is already apparent from those answering affidavits that have been filed is that there's, not surprisingly, a major overlap in many of the points that they're raising. And one would hope that no colleagues for the respondents or for ourselves, for that matter, would repeat anything other colleagues have argued. So I'm sure that there will be some who say, I don't want to present any oral argument, or if I do, I'll just be a few minutes. Others will want to be much longer. And we'll be able to reach consensus, I'm sure, my Lord. And my Lord, can I suggest we take up a friend's suggestion that in that week of the 9th of November, that conference will be convened. As I understand it, your Lordship doesn't want or need to preside over that meeting because you want to leave it to the parties.
I prefer to leave it to the parties, and it's only when the parties cannot agree, that I will then convene one that I will guide the whole process.
So we could then approach your Lordship's registrar to convene a case management meeting in that unlikely event.
Yeah.
Thank you, my Lord. My Lord, a further point I just want to put on record here, and that is after discussions between the SIU and the 35th respondent, the application is to be withdrawn as against the 35th respondent, but that will be done by way of formal notice. My Lord. Your Lordship doesn't need to make any ruling or record anything at this stage. My Lord, may we raise a point that was raised by our learned friend, Mr. Witz, for the 4th and 38th respondents. My Lord, they have raised an issue which has featured in some of the answering affidavits for some of the other respondents. It's not a point on which we need to argue, Your Lordship, or need to trouble Your Lordship for any ruling. I'm simply putting it on record, my Lord. The order that was granted originally, that we sought from Your Lordship and was granted, as Your Lordship pointed out, in August, was directed specifically at seizure in relation to the seizure of particular amounts held in bank accounts, was directed at the specific amounts that were listed in Annexure A to Your Lordship's order, because those were the amounts that we contend were part of the proceeds of corrupt activities justifying a forfeiture order. My Lord, apparently what has happened in practice is that some, if not all of the banks, have attached or frozen the entire bank accounts of individual respondents, whereas that was not the intention. That was not the order, although some parties suggest, Mr. Witz suggests that it may have been perhaps mistakenly the effect of the order. That was never the intention. And what I've said to my learned friend, and he has indicated that he is satisfied with it, although he can obviously say whatever he wishes in a moment. We have an agreement, as I understand it, that the SIU will send out a letter confirming that that was not the intention, and that the banks are required only to freeze the particular amounts that are referred to in Annexure A to Your Lordship's order. And that will be done. As I say, my Lord, I don't believe it is controversial today, and we believe it has been resolved, and we will give effect to the undertaking given by Council now to their Council. Perhaps my learned friend can indicate.
It's more than one party that raised there.
Sorry, my Lord?
My sense when I read the affidavits, I had a sense that it's more than one party that believes that the whole account has been frozen. And that's not the order that I gave. And I think the interpretation or understanding of that order, it may well be that the Financial Intelligence Center has made that separate arrangement because they have the authority to approach a bank and actually close down an account. But in the order that I gave, I did not say that the bank must freeze the entire account. That I did not do, because otherwise then the banks were not respondents. If you have noticed from the order, the banks are not cited as respondents. So it may well be, Mr. Kennedy, it may well be that you take this occasion, what you are explaining now, to make it clearer as we extend this Rule 9I. Put it clearer in the Rule 9I that what you as SIU had asked for and you want to extend is in respect of that particular amount in the bank account and nothing more.
Maybe then add a paragraph to the draft order.
It may have to be for clarity's sake, because even those who anticipate, some of them were under the impression that they cannot trade, unless, of course, they wanted to trade with the amount that has been attached. But they felt they cannot trade. They could still deposit some monies in the bank and withdraw them, but not that amount that was identified. So it's about the interpretation of the order. Perhaps the wording was not that quite specific. So you may have to do that, and so that then people are at ease.
As your Lordship pleases, we'd be happy to. I think it may be necessary, I'm afraid, my Lord, to stand up just so that we can put in a wording to that effect, because that will need some careful thought.
Yes.
I'm ready to hand up the draft order with the dates that have changed, but I'm not yet ready to hand up one with that particular provision.
Yes. Anything else other than that?
No, my Lord. I believe that's all. May I just have a moment? Thank you, my Lord. Those are our submissions.
That is all. Okay, you suggest that I should adjourn for you to make those changes?
Yes, my lord.
Yes. Is there anything else that any council want to raise at this stage? Not necessarily related to what Mr. Kennedy was saying. Mr. Mngube, you don't want to say something good because it looks like we are seeing you for the last time today. You are representing number 35, isn't it?
Indeed, so much.
Yes.
Yes. So I had communicated with my learned colleague. I think our matter will be attended to with my appropriate time.
Good luck. Thank you. Yes.
Yes, thank
Yes,
you.
Mr.
On behalf of the 4th and the 38th respondent, I confirm what my learned friend has said, and I mean, I understand what your lordship has said, and we accept that that was the intention of the order, but the minute the banks, never mind see FICA, they see SRU, they're scared to do anything. So, for example, we've got an overdraft facility. We can't use the bank account. We're not happy with what's happened, the 4th and the 38th respondent, because we'll deal with it at a later stage. We allege we're not involved in any of the corrupt, tainted, and all these other activities that have been alleged. But most importantly, we can't pay salaries, SARS, wages. We can't do anything. We can't utilize that bank account because the bank have taken the attitude, because it's the SRU and that's the order, that whole account is frozen. And I understand, and what my learned friend has correctly said, and what your lordship has pointed out, that wasn't the intention to freeze that. So we completely tied up. We can't do anything. We can't do business, and we can't operate the bank account. We're not happy to leave the amount there, but for the purposes till the order's made, we're happy to say that is what is attached. We leave that till when the matter is disposed of and concluded. However, we would like to operate that bank account, excluding the amount that's been attached on the interim order, and we can then do our normal business, pay SARS, pay wages, salaries, suppliers, etc. It's a company account, and we've got the facility and we're not allowed to use it. So if that can be clarified, we'll be more than satisfied and happy. And I think my learned friend, Advocate Kennedy, Senior Counsellor, said it, together with his June and all the parties, there is a good spirit amongst everybody, and if we can cooperate on these simple issues, I think that most of the parties will be satisfied up and until the matter is concluded. That's all that we're really asking for at this stage. Thank you, Lord.
That's why
and the dates are fine.
That's why I'm prepared to clarify it by way of a court order.
We'd
it should be
appreciate
part
that.
of the court order.
Yes, then the bank
Yes.
will react.
Then you are able to take it to the bank to say
Correct.
this is the situation.
That's it.
It should be clarified, yes.
Yes, they've got this fear of your order and the SRU. They see SRU and they see the order, even though they're not involved in respondents. The minute they see that, they don't want to do anything. They're too scared. Maybe in a way it's a good thing, but it's also a bad thing.
Of me or of the order. Okay, we'll have to attend to that. Of course, that was the sense when I read the affidavit. I realized that it looks like some of the respondents didn't understand the extent of the affidavit. I was careful when I gave that order, because the first thing I checked was whether the banks are cited as respondents.
Yes, my lord.
And they were not. And the application was really towards the respondents and not much the banks. The banks are merely there to carry out what the obligation
What the
is.
order and
Yes, so then I think we must make it specific so that then they understand what is meant by that order without necessarily having to vary it substantially.
Correct, we don't have to do that.
Yes.
That will be fine.
Yes.
We'll be satisfied with that. Thank you, Lord.
You're with us, Mr.
We're
Kennedy.
indebted to the court.
Because you are for the applicant, you are with us.
Yes, indeed, my lord.
Yes, I'm not giving a variation of that order.
No.
All I'm saying is put in a clause that explains it clearly so that then respondents must not be prejudiced. Those who want to use their accounts must do so, and provided that amount that has been identified must always remain in that account.
Indeed, my lord, we'll do so.
Yes.
We can point out that the first paragraph of Annex A dealing with Ledler is different to all the other paragraphs and all the other respondents. All the other respondents have a specific amount, and it is that is the limit of the freezing order in effect. In the case of Ledler, the first respondent, however, which your lordship ordered previously, was all the funds held in in that account for the reasons that were motivated in the founding affidavit.
Yes.
So, but we will work out a wording and share it with our learned friends who may want to have input on it before we come back to your lordship, so that we don't have any debate or controversy when your lordship comes back, if at all possible.
Yeah, okay, fine. I will be in my chambers, and
Thank you.
you'll let me know as soon as you're
We'll
done.
do so. Thank you.
Hopefully before 1 o'clock.
Yes, we'll do it as quickly as we
And
can.
then I'll come back and make it an order of course.
Thank you very much.
And then, is there any argument on the question of costs? What did you say on the question of costs?
We've provided simply that the issue of costs be reserved, my lord.
To be dealt with later.
That's correct, my lord.
Okay, thank you. Thank you. We will adjourn then until you let me know when that is ready. Yes.
I understand Your Lordship's registrar has the revised draft order. May we thank Your Lordship for allowing us to stand down to correct it. Unfortunately, there are a couple of typing errors that have been corrected in hand. I apologise for that. My Lord, as far as I know, all the different counsel and attorneys who represent the various parties have no difficulty with the amended order. And we've incorporated the revised timetable as discussed earlier, my Lord, the changed dates for the hearing in paragraph 1. Paragraphs 2 and 3 remain the same. Paragraphs 4 and 5, that's the revised timetable for the filing of heads by the respective parties. 6 simply reserves the question of costs, and 7, the handwritten changes are merely typo errors, so the special tribunal should have capital letters, and we've inserted the word per before Your Lordship's name. And then we've deleted the duplication of costs, the cost provision in 9, because that's already dealt with in 6. So, my Lord, as I understand it, although our learned friends will indicate if our understanding is wrong, everybody consents to this order, and we would move for it to be made an order of the special tribunal. Thank you, my Lord.
Thank you. I see number 9 relating to cost has been cancelled. Is it reserved or what is going on?
My Lord, that was one of the typing errors, but in fact 9 should be deleted because 6, which I originally intended to have put down as the new 9, has unfortunately been kept in, but that's at least got the correct wording of reserved rather than referring costs. So if Your Lordship, I thought it had been corrected, paragraph 9 should simply be deleted and costs are dealt with in paragraph 6.
Yes.
Thank you.
I've also made some changes in regard to the spelling of my surname here. Mr. South, I thought you'll help them with that.
I'm sorry, my Lord, I didn't pick that up. Thank you, my Lord. In fact, at the top of the page as well.
Yes. Do I get confirmation from all the respondents? Is there anyone who has objection to this draft order? Okay, fine, no objection. Then the draft order, which I mark X, is made order of court. In essence, it means that the Rule 9I is extended to the 20th, and we'll see it on the 20th and the 21st November for hearing, November 2020. The first 13th and 14th respondents and any other respondents which wishes to file answering affidavit shall file their answering affidavits by 12 October 2020. The applicant shall file replying affidavits in respect of all answering affidavits to which it has not yet replied to by 26 October 2020. The applicant shall then file heads of argument by 28 October, and the respondents shall file the heads of argument by 4 November 2020, and the costs are reserved. The other two paragraphs deal with an explanation as to what the order means, the original order granted in August means. Having said that, then, we adjourn the proceedings until the 20th of November, and the Rule 9I is extended until then. And this draft order here, which I signed, is made order of court. We are adjourned.
All right.